So we're gonna start officially our final session. Enjoy, and I just wanna ask you agree otherwise, or should we start with the Claimant for 14 minutes, and then the Respondent for another 14 minutes, and then answer etc. for 1 extra minute. Is that right?
Madam Presiding Arbitrator, the parties have agreed. In regards to the order, the parties have agreed to start with the procedural issues with Respondent, followed by Claimant, and then move on to the merits of the case, starting by the Claimant, followed by Respondent.
Okay, exactly what I am asking if you decided otherwise. So please go ahead with you both agreed.
I think I have 15 minutes for the Claimant and another 15 minutes for the Respondent.
But they agreed on 14, right?
14,
14 and
I'm
then
sorry.
Just want to have extra ones first.
I'm sorry.
Is that right? Isn't it?
Yes.
So good afternoon, members of the Tribunal. My name is Camila Paz, and I'll be addressing the Respondent on the procedural issues of this dispute. In 2023, the parties concluded the purchase and service agreement for the construction of a green hydrogen. However, due to the delayed delivery of final plans by Claimant, Respondent terminated the agreement, which led Claimant to initiate his arbitration without first fulfilling the mediation requirement under Article 30 of the CISG. So it is for this reason that its Respondent's first submission to the Tribunal lacks jurisdiction and the claim is not admissible. Parties here also disagree on the admissibility of 2 documents, which are Exhibit I3, which is an email sent by Claimant's in-house counsel to Claimant's CEO, and Exhibit 7, which is a without prejudice offer sent by Claimant to Respondent. So in case the Tribunal decides that it has jurisdiction when the claim is admissible, it is Respondent's second submission that Exhibit R3 should be admitted into this arbitration, while Exhibit C7 should be excluded. Moving to the first point, this arbitration cannot move forward. And this is because the Tribunal lacks jurisdiction and there was a specific condition present under the dispute resolution clause that established that mediation must occur prior to arbitration. And the failure to fulfill such condition present impacts directly the operability of the arbitration agreement and consequently the Tribunal's jurisdiction. The operability of the arbitration agreement means the capacity of the clause to further produce effects. To analyze issues such as operability, the Tribunal can give regard to the substantive law because matters of interpretation of the arbitration agreement are substantive issues, and this is the understanding of Professor Giovanni Zaha, who is a professor at the University of Naples. And under Article 531 of the General Contract Law of the Cotidiano, implies that a obligation will only take effect, meaning become operable, if a specific condition precedent is fulfilled. And for a clause to qualify as a condition precedent, there are two criteria that should be analyzed. The first criterion is the mandatory language of the clause. The second criterion is the specificity of the clause. Regarding the first criterion, the usage of terms such as shall and must are clear indicators for this mandatory nature of the clause. This was exact understanding in the Max Engineering Works versus PQ Builders from 2022, where the High Court of Singapore held that the wording of the clause that read, shall refer the dispute for mediation, obliged the parties to actually refer the dispute mediation. Now, if you're going to follow me to page 12 of the files. This is the purchase and service agreement concluded between the parties. And under Article 30, which is the dispute resolution clause, it reads, and I quote, any dispute, controversy, or claim arising out of or relating to this contract, or the breach, termination, or validity thereof, shall first be submitted to mediation in accordance with the mediation rules of the Philippine Chamber of Commerce. And here we can see that the first criterion of the language requirement is fulfilled here. So in this sense, the clause following the language that qualifies as a condition precedent. Now moving to the second criteria, which is the specificity of the clause has to contain elements to be sufficiently certain so it can be actionable by itself. And on the next page, which is page 13 of the case files and page 15 of the PDF, in the first two lines, we can see that it not only provides the place of mediation, but also the language of mediation. So here the clause not only contains these two criteria, but most importantly has the institutional rules which will govern this mediation. So here we can see clause is in fact sufficiently specific in the sense it follows the criteria for it to be qualified as a condition precedent for arbitration. And since both of these criteria have been met, it is in fact the current state of the law in Ecuadoriana that the non-compliance pre-arbitral steps, such as mediation, as it happens in the present case, would in fact be a jurisdictional issue that would directly impact the jurisdiction of the arbitrator. And this is also what was ruled in the Lufthansa case from 2014, where the Singapore Court of Appeal held that the failure to fulfill the mediation with a mandatory pre-arbitral step would in fact undermine the tribunal jurisdiction and be considered as a condition precedent arbitration. The respondent here understands that this is in fact a controversial issue, as it might be consistent case law pointing directly the opposite, that this might be a case of admissibility on the other hand. However, members of this arbitral committee, only relevant jurisdiction here, which is not only the law of the country and the place where an award would most likely be enforced, which is Ecuadoriana, it is the state of the law that questions relating to pre-arbitral steps are to be considered jurisdictional matters. So in this regard here, we see that when following the only relevant jurisdiction, the tribunal would not in fact have jurisdiction. This is also relevant here when we analyze that even if the tribunal decides that it has jurisdiction, the claim still not be admitted. This was always parties' intention for mediation to occur prior to arbitration. Tribunal, follow me to page 30 of the case files. And 32 of the PDF. This is the witness statement of Mrs. Johanna Ritter, which the respondent's head of contract. And on paragraph number 9, on the fourth line, starting with irrespective, is presiding arbitrator with me? Yes. It reads, and I quote, irrespective of that, I definitely told him that we had a strong interest in an amicable settlement of disputes, and arbitration should only be the last resort to resolve disputes. So here, respondent not only implied that mediation must occur prior to arbitration, but claimant actually agreed with this statement. You're going to follow me to the next page, page 31, then page 5 to page 33 of the PDF. This is an email sent by claimant to respondent during the negotiations of the PSA. And on the second paragraph, on the 5th line, starting with furthermore, it reads, and I quote, furthermore, the FII model mediation clause suggested by us clearly provides that the party must first try to mediate their dispute before resorting to arbitration. Thus, arbitration is only the last resort as you wish. And not only that, but claimant itself excluded the one provision in the model clause that suggested the mediation was not an obligatory condition. So when analyzing both the language of the clause and the parties' intention here, we can see that mediation is always meant to occur prior to arbitration. Exactly for this reason, that's why the tribunal must decide that the claim is not admissible in the present case.
Carolina, let me interrupt you. And you mentioned that prior mediation is mandatory, but there is no specific time limit for that. Would you consider the wording of the clause fulfill to be really a condition, even not having a time frame for that, even not having an institution? Because when the clause afterwards provides arbitration, indicates institution and all the details for arbitration, there is no institution for the mediation. So it would be that documentation, the conversations we know, and we have elements on the case indicating there were a negotiation and indicating parties met and at least trying. Is not that a mediation as it is an ad hoc mediation?
An arbitrator first, it is not a ad hoc mediation because the parties provide for the FII constitutional rules to govern this mediation.
Weird.
And on page 12 of the case files, on Article 30, on the end of the line, it reads that mediation in accordance with the mediation rules on the field and general purpose.
Okay, applying the rules, but not before the institution. You can have an adaptation applying the rules, but is that equal before the institution? Applying the rules is the same?
An arbitrator, what respondent contends here is that the requirements for the clause of fire express are fulfilled. Because the time limit suggested is not a requirement. Because the time limit only exists so parties can have a opt-out of mediation when it seems that mediation is not going to be fruitful. However, the own institutional rules that are chosen by the parties to govern the mediation after mediation has started, its own Article 2.e establishes that there is a timetable for mediation. And not only that, it actually provides that an own mediator can stop mediation when it seems that it's not going to have any fruitful result. So for this reason, when analyzing the time limit, we can see that it is fulfilled by the own addition of the institutional rules. So for this reason, we can see that it is in fact a condition precedent to the tribunal lacks jurisdiction.
Ask you another question. Do you think this mediation has any chance of success? And do you think this impact on your argument? I would like to hear your view on that.
Mr. Arbitrator, yes, mediation here would actually have a rate of success. Because respondent can never show any treason behavior. And actually was claiming that closed the door to any further negotiations. Here we have a real possibility of an amicable settlement, avoiding any litigious proceedings. So, and actually what it was important is that mediation is in fact mandatory. Here we can see that the parties always wanted to occur and that respondent is open to a amicable settlement.
Let me make another question. I would like to call your attention to Exhibit C7. I know that you are going to approach this issue on your next argument, but there is a line here that calls my attention, saying, please be aware that the minister, Mr. Event, will only agree to the continuation of the project if the hydrogen is produced at a price that makes it competitive. to be competitive with a 50% price reduction. Any further discussion between you and lawyers only makes sense if Green Hydro is willing to accept a serious price reduction. Do you consider that is an open door to mediation?
Arbitrator, your answer is to first, this document, as will be demonstrated, is not admissible into this district. However, even if we were to analyze the content of this document, we can see that this is a mere aggressive business tactic for my client, which by no means suggests my client's final position on this issue. Because in fact, this year actually depended on the studies of whether a production of green hydrogen was still possible. This is not a ultimatum sent by our client, as it was a real variable possibility for parties to get to a negotiation. It was actually Claimant that based his decision on the start this arbitration on an informal communication, a one-side assumption that mediation was not going to be fruitful. For this reason, this document cannot be admitted and actually does not prove my client's final position. And I see that my time is about to run out. I could have an additional 2 minutes to make my second submission.
Yeah, yes, please.
Thank you. So, but in case tribunal considers that it has jurisdiction and the claim is admissible, respondent will demonstrate that exhibit R3 should be admitted as it is not protected by attorney-client privilege, and exhibit C7 should be excluded as it is protected by without prejudice privilege under the applicable law. But first, regarding exhibit R3, which is an email sent by claimant's in-house counsel to claimant's CEO, this document is not protected by attorney-client privilege. And since there is no provision establishing which law applies to privilege here, the tribunal can make this determination. And by doing so, in cases of international arbitration, parties come from different legal backgrounds, different jurisdictions, with different lawyers, the most adequate approach to ensure predictability and certainty would be kept by creating a connection between the law that applies to this document and this document. It will not make any sense to apply a law that has no real connection with the document being produced. And this was the exact understanding that was held by the ICC case 35054, where it decided when analyzing the admissibility of a document of parties that came from different backgrounds, it decided to apply the closest connection. And by applying this test, there are two criteria to determine which law has the closest connection. And those are the domicile of the party who is seeking to rely on privilege and where the lawyer or the legal in the bar. And both of these criteria lead to the same law because it's the law of Mediterranean, because either as claimant has its administrative center and where its lawyers were admitted in the bar. And under the law of Mediterranean, there is no rule protecting communications by its in-house counsel and its lawyer from being disclosed in present proceedings. For this reason, exhibit R3 has no legal protection and shall be admitted into this arbitration. Now, regarding exhibit 7, which is a without prejudice offer sent by claimant to respondent, this document cannot be admitted into the arbitration as it is not protected by attorney-client privilege. And under this law, it shall apply the law of Equatoriana under the closest connection test because this document was made during the context of negotiation and during the governed by the law with the contractual law of Equatoriana. And under the law of Equatoriana, in its article 2.1.16, it reads, and I quote, where information is given as confidential by one party in the course of negotiations, the other party is under a duty not to disclose that information or to use improperly for its own purposes. This is precisely what happens here, because Exhibit 7 was made in the context of negotiations and actually does not by no means show my client's final position. It cannot be used in an arbitral proceedings to determine when the client did not want to mediate.
Carolina, I have a point here because I am quite confused and if you could help me understand. You mentioned in your previous argument there is no fulfilled precedent condition related to mediation. And now you are invoking the confidentiality of mediation to protect the exhibit of this document. So we do have the precedent condition of the mediation and all the elements of mediation and the confidentiality and the protection of mediation, or we do not have a previous mediation and as a condition present. I am quite confused regarding that. Please.
Madam Arbitrator, today my time has run out. If I can answer the question and report my submissions.
Okay.
Yes. Actually, Madam Arbitrator, what the law protects is the negotiations and what this document is produced or in the context of negotiations, and both parties have a reasonable expectation for this document to be kept confidential, as it is without prejudice offer, has no means for being a binding document in any arbitral proceedings. Thank you, and for this reason, Respondent reinforces its submissions and thanks the tribunal for its time.
Here. No, no,
So
Madam Presiding Arbitrator, members of the tribunal, opposing counsel, good afternoon once again. Allow me to introduce myself. My name is Juliana Viegas, and I'm here today alongside my co-counsel, Tomás Grua, on behalf of Green Hydro PLC, claimant in these proceedings. I'll start by addressing the procedural aspects of the present dispute, while my co-counsel will later assist the tribunal with the substantive issues. Members of the tribunal, arbitration may not always be a straight bridge to resolution, but is certainly not meant to be a mix. Yet, respondent is trying to make it one by imposing unfounded obstacles at every turn of these proceedings. But these hurdles cannot become procedural barriers, as they have no basis in the contract, the applicable rules, or the facts of the case. Their only purpose is actually to delay this arbitration, and this tribunal should not allow it. In order to better demonstrate that, and for the sake of clarity, I'll structure my arguments on the same order as presented by counsel for respondent, demonstrating conversely that first, this tribunal has jurisdiction to hear the case and the claim is admissible. And second, that respondent's exhibit number 3 should be excluded from the case files, while claimant's exhibit number 7 should be maintained. But before addressing my first issue, it is important to clarify to the tribunal from the outset that we're not dealing with a matter of jurisdiction. There's no challenge to the validity of the arbitration agreement, no issue of consent, and no reason that would prevent this tribunal from exercising its authority to hear and decide on the case. Also, the arbitration agreement meets all the formal requirements established in Article 7.1 of the XIII Model Law and International Commercial Arbitration. While trying to challenge the jurisdiction of this tribunal, my opposing counsel acknowledges that arbitration was meant as a last resort. This only proves that the parties in the present dispute had clear and unequivocal intent to submit the dispute to arbitration, just as in the case NWA versus NVF, in which the High Court of Justice of England held that, and I quote, "The failure to conduct the mediation in this case does not mean that there were not a valid arbitration agreement, or that the agreement arbitrated is inoperative." End of quote. This case is even more recent than the case cited by my opposing counsel, is from 2021, and the court further emphasized that when an agreement states that the disputes shall be finally resolved by arbitration, mediation is merely a procedural step, not a jurisdictional barrier. Therefore, at most, respondent's objection regards the admissibility of the claim. But even that argument does not stand. Contrary to what my opposing counsel alleges, mediation is not a condition precedent to arbitration in the present case. The preamble and Article 11 of the FAI mediation rules chosen by the parties expressly provide that, unless otherwise agreed by the parties, an agreement on FAI mediation does not constitute a bar to any judicial, arbitral, or similar proceedings. Members of the tribunal, no such agreement exists. Counsel for respondent argued that the wording of the clause, together with the intention of the parties, indicates that mediation was mandatory, but that is not the case. First, because the use of words such as shall and first is not relevant to determine whether mediation is mandatory. In fact, These words appear in the FAI model mediation clause and are very common in dispute resolution clauses. If this wording was enough to impose such a strict obligation, then every dispute under the FAI mediation rules would require a mandatory mediation, which is certainly not the case considering that the rules provide for the opposite of that. And second, because the dispute resolution clause we have in the present case does not in any way establish that arbitration could only be commenced after mediation was concluded. It sets no time frame for mediation, nor does establish any procedural consequences for failing to engage in this process. On this matter, my opposing counsel stated, and I quote, "The clause has to contain elements to be sufficiently certain." But my opposing counsel failed to point if those elements are contained in the present case, because they're not. Under Article 14 of the UNCITRAL Model Law on International Commercial Mediation, a tribunal will only give effect to a mediation requirement if the parties have expressly agreed on a certain time limit or a defined event marking the conclusion of the mediation. Without that, there is no clear cut between the mediation and the arbitration. Paragraph 31 of the FAI mediation guidelines also highlights that mediation is a voluntary process, unless the parties have agreed to the contrary by deciding to mediate for a certain period of time. Without sufficiently clear terms, no enforceable obligation exists, members of the tribunal. And last but not least, my opposing counsel relied on Respondent Exhibit number 2 to try and prove that the parties intended for mediation to be mandatory. However, a closer look at the context behind this communication shows a different picture. Although the parties may have intended to try to reach an amicable solution, they do not in any way impose that this would be a procedural step prior to arbitration, a mandatory procedural step. The wording of the clause makes it impossible for this tribunal to assess that mediation was an absolute bar to arbitration. The reality of the matter is that it was merely a guideline, not a mandatory procedural step.
Juliana, if I may, you mentioned the clause having elements, and I am reading the clause here, and I can find elements like a chosen of the rules, applicable rules, place where the mediation should happen, the language. These items cannot be considered having elements, to be the elements, even not having a time frame. And another consideration, you mentioned mediation is a voluntary. The contract and the clause and the wording of the clause, it was a conclusion of the voluntarily options of the parties. So if there is a clause having a provision of the mediation before the arbitration is not the intention of the parties working here to voluntarily go for mediation and try a mediation before the arbitration is not that the factus servanda, as far as I know. I am not starting a discussion related to the applicable law and etc., but just as a comparison. So you agree upon this clause with a mediation provision. And you consider these negotiations, these previous negotiations, fulfilling this mediation?
Madam Presiding Arbitrator, answering your first question, the elements of the choice for a place of mediation and language are not enough. In the present case, if we do not establish a time limit for mediation, then claimant would never know when it would be able to start an arbitration. There's no clear cut between mediation and arbitration. With that, respondent could delay the mediation so that we will never reach the arbitration.
But knowing it is voluntarily, you could stop the mediation. Enough, I will not go to mediation anymore. Is that possible? It would be possible, better say.
Madam Presiding Arbitrator, to answer your second question regarding the mediation, the parties surely can agree to mediate, and they had an intention to mediate here, but this is not a mandatory procedural step. It's a mere intention to mediate as a useful tool in varied disputes. So mediation could be an intention of the parties in the present case, but this does not in any way affect the jurisdiction of the arbitral tribunal or the admissibility of the claim. In the present case, mediation was not a condition, precedent, and mandatory agreed between the parties. That's why this tribunal should admit the claim and proceed with the arbitration.
The respondent also mentioned the deposition of Miss Joanna Wheeler, on which she mentioned that the parties had a strong interest in an amicable settlement of disputes. I would like to hear your view on the drafting history of the clause.
Of course, Mr. Arbitrator. It was claimed, first of all, it's important to establish in this tribunal that it was claimant that drafted the clause. The parties never discussed the application of a time limit to mediation, which is also, as I posed, an element that shows that they never meant it to be mandatory. But there were discussions between the parties to try and reach an amicable solution. But they never posed it like an obligation, but merely an intention to try and solve the dispute in an amicable way. So although the drafting history of the clause does not reveal to us that mediation was mandatory in the present case. So we should reach the same conclusion when analyzing the drafting history. Having settled my first issue, I now move on to the second issue of my arguments concerning the admissibility of evidence. On that matter, my opposing counsel states that we should exclude claimant's exhibit number 7 from the files and maintain respondent's exhibit number 3. However, the conclusion that this tribunal should reach is precisely the opposite. Regarding respondent's exhibit number 3, this document must be excluded from the files for 2 reasons. First, it was illegally obtained, and second, it is protected by attorney-client privilege. Members of the tribunal, the facts of the case strongly suggest that this document was obtained through improper means. Weeks before it was submitted by respondent, the police of Equatoriana raided the office of claimant's head of contracting, Mr. Gaiman, and confiscated all of his documents. It is more likely than not that respondent gained access to that document through that investigation, especially because its employees had a very close relationship with the prosecutors handling the case. In fact, respondent's head of contracting, Ms. Johanna Ritter, even admits that she learned about the content of that document through a friend involved in the investigation. Under the balance of probability standard, this tribunal has more than sufficient grounds to exclude respondent's exhibit number 3 on the basis that it was illegally obtained. And therefore, in that way, the tribunal would protect the integrity of these proceedings. But even if the tribunal considers that we do not have sufficient evidence to show that the evidence was illegally obtained, which is not the case, it must still exclude the document from the files because it is protected by attorney-client privilege. Respondent suggests on this matter that we apply the closest connection test, which would lead to the application of the law of Mediterranean. However, claimant submits to this tribunal that we should instead apply the most protective law, which is the law of Equatoriana. This approach ensures equal treatment to both parties and prevents procedural unfairness. Applying the highest level of protection is the best way to ensure that none of the parties are placed in a disadvantage. Under Equatoriana law, attorney-client privilege applies when 2 conditions are met. First, the in-house lawyer is a member of the bar, and second, the communication contains legal advice, which is exactly the case. Applying Mediterranean lower standards in the present case would violate the principle of equality of arms. What respondent really wants, members of the tribunal, is to have unrestricted access to all claimants' privileged documents, while its own communications with its counsel remain off limits. But this creates a clear and unacceptable imbalance that this tribunal should not accept. Turning now to the last issue of my arguments regarding claimant's exhibit number 7, claimant submits that this crucial evidence should be kept in the case files. First, because there is no legal basis expressly providing for its exclusion. But more importantly, because claimant's exhibit number 7 is not a real and genuine attempt to negotiate. As I've shown this tribunal already, Respondent made an offer that it knew claimant could not accept. It was not a reasonable offer. It was not a real temptation to try and negotiate. So in the present case, not being a real offer, we cannot consider this protected by settlement privilege. Not only that, but the email was not in the context of a mediation or a formal settlement dispute, mere negotiations between the parties that would lead nowhere. But respondent remained inflexible. So since this document is very important to members of the tribunal, I see that my time is elapsing. May I ask for an additional 30 seconds just to conclude my submission?
Sure.
Thank you very much for that. Since this document is very important for claimant to show to this tribunal respondent's unwillingness to mediate, this must be kept in the case files considering its relevance. Therefore, claimant requests that this tribunal first declare that it has jurisdiction to hear the case, second, admit the claim, third, and finally, maintain claimant's exhibit number 7 on the files and exclude respondent exhibit number 3. Thank you very much, members of the tribunal.
Juliana, you mentioned an issue on the document was obtained legally. Is that a suspicious or you know something happened about the history and the context? Because I got the impression it's merely a suspicious of that.
Madam Presiding Arbitrator, although we do not have proof that this document was illegally obtained, since this proof is very hard to obtain, in the present case, we have a lot of evidence showing that this document was most likely obtained through improper means. And in this case, claimant submits that this tribunal should apply the balance of probability standard. So if it's more likely than not that the document was illegally obtained, then that is sufficient. And this rationale was applied in the ICC case number 20125, in which the tribunal understood that the standard of proof in finding the facts necessary to establish the proposition is the simple balance of probabilities, neither more nor less. So in the present case, if the tribunal understands.
Sorry, where does it come from? You call it. Where is it?
It's an ICC case,
Yeah.
which was ruled in 2016 between Modern Industrial Investments and Healthline Holding Group. So in the present case, if this tribunal has indications that the document was illegally obtained, especially because it's a communication between claimant's internal counsel and claimant's head of contracting, which is most likely the respondent obtained this document illegally since it's an internal communication from claimant, this tribunal should exclude respondent's exhibit number 2.
This case is from 2016.
Yes, precisely.
We have updated jurisprudence for the matter.
I also
It's the only precedent that we
No, Mr. Arbitrator, this is not the only precedent. We also have an exit case of 2021 in which they determined that the graver the charge, while agreeing, I may read the quote for you. While agreeing with the general proposition that the graver the charge, the more confidence there must be in the evidence relied on, this does not necessarily entail a higher standard of proof. It may simply require more persuasive evidence in the case of a fact that it is inherently improbable. So in the present case, claimant contends that we have persuasive evidence that the document was illegally obtained, and that is more than enough.
persuade evidence, but you said that you didn't have evidence that the was a big thing. How does that apply to the case?
Mr. Arbitrator, we do not have factual proof that this document was illegally obtained, but we have a lot of evidence. The fact that respondent's own head of contracting admits that she learned about the content of the document through the investigation, and the fact that this investigation was requested by respondent shows that it was most likely illegally obtained. So we have more than sufficient grounds to understand that it was obtained through improper means. But even if the tribunal understands that we do not have sufficient evidence, the document must be excluded anyway because it is protected by attorney-client privilege. So we would reach the same conclusion.
On that matter, can I ask you a question? You just mentioned that the document is protected by attorney-client privilege, but would your arguments prevail if we consider that it's an internal correspondence, I mean, it's an internal message between employees of the same company, it's not an outside counsel, so would your arguments be, I mean, be the same? Do they prevail in that matter?
Madam Arbitrator, could you please rephrase your question?
No,
I'm
no
sorry.
problem. It's because you mentioned that the correspondence, right, with R3 is protected by client-attorney privilege, right? But in this case, if I'm not mistaken, the document is sent by Mr. Smith, who is an employee of a Claimant, right?
Exactly.
And it's an internal, it's not an I mean, it doesn't come from outside counsel, it's all internal. So do you believe your arguments prevail in that case? I mean, you just talked about attorney-client privilege, so would
Does
the
privilege
arguments be the
apply?
same? Yeah, does it apply to the case?
Yes, Madam Arbitrator, it still applies to the case. There is a provision, even under the law of Mediterranean, which is the respondent's proposition. The ethical rules explicitly state that the communication between counsel and clients must remain confidential. There is no explicit provision that this communication must be between counsel, internal counsel, and external clients. So in the present case, we would reach the same conclusion, that is, that this document is protected by privilege.
So please, 1 minute.
Members of this article review, Claimant here completely ignores that in the only relevant jurisdiction, which is Equatoriano, the matters of non-compliance litigation are considered to be jurisdictional matters, which means that it should be no left jurisdiction. And in the present case, since the condition precedent has mandatory language sufficiently specific, this would be a matter of jurisdiction under the law of.
Of course, thank you again, Madam Presiding Arbitrator, members of the tribunal. Respondent only poses that Equatoriana is the only relevant jurisdiction because it is in its favor. So what respondent really wants here is home court advantage. The applicable law to the arbitration agreement is actually the law of the seat, which is the law of the Nubian. So respondent cannot try to take advantage of the law of Equatoriana only because it has case law in its favor when the applicable law is not the law of Equatoriana. Thank you very much.
In the next argument, as far as I understood, you start now a different way, isn't that?
Yes,
right?
Madam
You
Mayor.
start with the Claimant.
That is correct.
So, please. Okay.
Please begin.
Thank you, Madam Arbitrator, members of this tribunal, opposing counsel. Good afternoon. Once again, as previously introduced by my co-counsel, my name is Tomás Groot, and today I'm here on behalf of Green Hydro PLC, claimants in these proceedings, to address the substantive issues relevant to the case at hand. Respondent strategy is crystal clear: to get home court advantage. As if drafting the agreement and then breaching it without legal basis was not enough, respondent now claims that the CISG does not apply to the agreement and asserts that the parties have excluded its application to the contract. The truth is, respondent simply seeks to apply the convenient law, which is the Equatoriana Civil Code. Such tactics cannot change reality, which is respondent leverages its status as a state-owned enterprise to dominate partners and suppliers. But these tactics won't stand here. For the sake of clarity, claimant will structure its arguments in 2 main points, demonstrating that, first, the CISG is applicable to the agreement, and second, that the parties have not excluded its application to the contract. Under Article 1 of the CISG, the convention is applicable to international contracts for the sale of goods. Claimant will now demonstrate that the agreement concluded by the parties is an international contract for the sale of goods.
Do you consider this conflict as an international contract of sale of goods? Isn't it more likely a turnkey construction agreement?
Mis-
Would like to hear your view on that.
Of course, Mr. Arbitrator, even though this is an EPC turnkey contract, the truth of the matter is it is also an international contract under Article 1 of the CISG. And that is because, for the purposes of the convention, what is relevant for internationality is the places of business of the parties to that contract. In the present case, the places of business and claimant and respondent are in different contracting states of the CISG, therefore fulfilling the requirements set upon by the convention. And that is because claimant's place of business is in Mediterranean and respondent's place of business is in Equatoriana. Therefore, the requirement set upon by the convention is fulfilled. But
Your question? Yes, so is that mean that the object of the contract, I mean, the purpose, being a construction contract and not sales of goods, there is no importance at all? That's right, you were base your argument upon the international aspect or the product aspect?
Madam Arbitrator, this is not a construction contract. This is an international contract. And it is an EPC contract which contains construction parts, but this is a sale of a good to be manufactured under Article 3.1 of the CISG.
This is a good or a service?
It's the plant which was to be supplied by claimant to respondent was a good under Article 3.1 of the CISG. The fact that a plant can be considered a good has already been recognized by courts, such as the German court, when analyzing the window production plant case. The case involved a German buyer ordering from an Italian seller a plant for the manufacture of windows. On that occasion, the German court concluded that the plant was a good to be manufactured pursuant to Article 3.1 of the CISG.
Please go ahead. You're done. Please.
Besides that, even if the tribunal is not convinced that this is a contract which involves a sale of a good to be manufactured, the truth of the matter is that the requirements set upon by Article 3.2 of the CISG are also fulfilled. Article 3.2 of the convention governs the so-called mixed contract. According to Article 3.2 of the CISG, the convention does not apply to contracts in which the preponderant part of the obligations of the party who furnishes the goods involves labor or other services. In order to understand what is the preponderant part of a mixed contract, the CISG Advisory Council Opinion number 4 suggests the use of the economic value criterion. In order to utilize the economic value criterion in the case at hand, claimant would please invite the tribunal to page 17 of the case files. This is claimant's exhibit number 5, which is the witness statement of Mr. Paul Cavendish, who was claimant CEO at the time of the conclusion of the contract. Now, this tribunal could please pay closer attention to paragraph 11 of the page. There's a specific table here, and it can be seen from this table. On the left, the first left column of the table, that the total investment of the contract involved 300 million euros. From those 300 million euros, the highlighted parts of the table indicate sale of goods. That is 190 million euros. So 190 million euros out of the total 300 million euros planned to be invested throughout the agreement consisted upon the supply of goods by claimant to respond. In other words, as supported by the Annex 1 of an arbitrator's brief, the fact is 63% of the contract involved the supply of goods by claimant to respond.
Are you consider the ammonia unit?
Mr. Arbitrator, even if we were to consider the ammonia unit, the conclusion would be the same. If the tribunal could please accompany me to Annex 1 of the arbitrator's brief.
Section. Yeah, I'm here.
Here, on the bottom of the page, there's on the left side of the bottom of the page, there's a small table indicating what would be the percentage of supply of goods and labor and services if exercised the e-ammonia option. The conclusion is the same. 62.5% of the contract would involve the supply of goods by claimant to respond. So from any perspective, the truth of the matter is the requirements for the application of the CISG under Article 3.2 are fulfilled. And the tribunal should recognize that the requirements for the application of the convention are met. But not only is the requirement set upon by Article 1 and Article 2 of the CISG fulfilled. On top of that, the agreement is not, cannot be excluded, the exception provided for in Article 2B of the CISG does not apply to the case at hand. And that is because the agreement was not concluded by the means of an auction, but instead of a public procurement tender process. According to professors such as Schlesser and Schwenzer, in these cases, the contract is not excluded from the scope of the CISG. In this sense, I would like to quote Professors Schlesser and Schwenzer as they say, quote, "It follows that a contract awarded to the highest bidder in a public international procurement bid can very well be governed by the CISG." End of quote. With that being established, at this stage of the arbitration, one thing is clear. Respondent strategy is simply not to apply the CISG to the contract because it is not convenient to its defense. But claimant has already settled that the requirements for the application of the convention are met. On top of that, claimant submits that this tribunal should recognize that the parties have not excluded the application of the CISG to the agreement. And this leads me to my second submission. When a specific contract fulfills the requirements for the application of the CISG, the convention is considered to be applied to that contract, unless the parties have excluded the application of the convention pursuant to Article 6 of the CISG. The rule under Article 6 of the CISG is that exclusion must be express. That is, for example, recognized by the German sportswear case, which was analyzed by a German court and involved a Swiss buyer and a German seller. On that occasion, the German court concluded that, and I quote, "The parties can only exclude the application of the CISG by explicit agreement." It can be inferred from the case files that the parties have not expressly excluded the application of the CISG.
If I may interrupt you, as far as I know, I am reading the contract itself, and there is an article governing law. The agreement is governed by the law of Equatorial, so is needed to exclude the convention, like expressly and opt out, because it's already a provision related to another law. So it's not that automatic, implicit that if you are choosing another law, you are not applying the convention. Is that still needed, this express wording, excluding the convention?
Perfectly, Madam Arbitrator. The truth of the matter is, the law of Equatoriana for international contracts for the sale of goods is the CISG. And that is because the CISG is a contracting state of the convention. That is because Equatoriana is a contracting state of the CISG. On top of that, implicit exclusion of the convention does not suffice when the parties simply indicate the law of a country, a contracting state of the CISG. That is, for example, supported by the CISG Advisory Council Opinion number 16. And I will quote a part of CISG Advisory Council Opinion number 16. Quote, "Choice of law clause indicates that the law of a contracting state governs this contract. Commentators, courts, and tribunals have widely accepted that, without more, this will not exclude the CISG, since the CISG forms part of the law of the contracting state." End of quote. The truth of the matter is, for implicit exclusion of the CISG, according to scholars such as Harry Fleckner, there are only two possibilities. The first possibility would be if the parties chose the law of a non-contracting state of the CISG, which is not the case at hand. Or else, the parties could have chosen the domestic sales law of a contracting state of the CISG, which has also not occurred.
I would like to question, you made your point that this is a supply of goods contract. But I would like to hear a view on that contract to be an international sales contract. Because I would like to hear your view on the relationship between claimant and Volta Respondent.
Of course, Mr. Arbitrator, it will be my pleasure to address this issue. Voter Transformer, even though it is as of now claimant's subsidiary, was only acquired by claimant on November 2023. The contract concluded by the parties was concluded on July 2023. That is, Voter Transformer was acquired months after claimant concluded the contract with Respondent. And according to scholars, such as Professor Franco Ferrari, the internationality of a contract must be evaluated at the time of the conclusion of the contract. For this reason, the agreement fulfills the requirements for internationality set by Article 1 of the CISG. Members of the tribunal, having settled that the CISG is applicable to the agreement and that the parties have not excluded its application to the contract, one thing is clear. Respondent simply seeks to cherry pick the applicable law which favors its defense in the present arbitration. But such tactics cannot change reality. The CISG is applicable to the agreement and the parties have not excluded its application to the contract. Thank you.
Again, good morning, members of the Arbitral Tribunal. My name is Mariana Carrera, and I'll be addressing respondent submissions on the merits of the dispute. Members of the tribunal, it is respondent who is cherry picking here by consistently ignoring the history of the parties' negotiations and the nature of the contract it willingly signed into, to now attempt to convince the tribunal to declare the CISG applicable here, a position respondent contests. Therefore, mirroring my counterpart's arguments, respondent will demonstrate, first, that the CISG is not applicable, and second, that the parties have validly excluded the convention's application. Regarding my first point, respondent recognizes that this is indeed an international agreement. However, there are two other entirely separate and independent reasons on why the CISG remains inapplicable. These reasons are, one, that this is in fact, as was pointed out by the tribunal, a turnkey agreement with a preponderance of services. And second, that this is in fact the result of a sale made by auction. Moving to my first point on the inapplicability of the CISG. Counsel for Claimant argues that the exclusions under Article 3 of the Convention aren't applicable here. First, Claimant brings the arguments that the plant is a good to be manufactured, making the CISG applicable under Article 3.1. To support this argument, Claimant brings the case window production case that was settled in Germany. But that plant is inherently different to the plant we have here. The window production plant had an inherent movability. It was made of small parts that could be assembled or disassembled at any given point. And that isn't the case with a massive green hydrogen plant. In fact, the definition of a good for the CISG, according to Professor Pascal Hacking, is that it has to be movable and tangible at the time of delivery, even if the finished product is movable. Yes, the finished product here is immovable, but it wasn't movable and tangible at the time of delivery. This is a turnkey agreement, and as such, with the delivery, the plant was already constructed and immovable. Now, regarding to Article 3.2 of the Convention, Claimant argues that the preponderant part of this contract is in fact the sale of goods. To support the argument, Claimant argues based on the CISG Advisory Council Opinion number 4. And while it is true that that Advisory Council opinion does recommend the economic value criteria, Claimant has conveniently left out that that same opinion also states that that economic value criteria can sometimes be inappropriate in determining the parties' intention. And in that case, we should use a qualitative approach, the essentiality criteria, and look at the importance of the goods to the success of the contract when performing an overall assessment to understand the weight given by the parties to each obligation. In fact, when courts use this qualitative approach, they emphasize the extensiveness of services. I'm so sorry. They emphasize the extensiveness of services provided. In the waste separation machines case, the Commercial Court of Canton Zurich decided that even though 80% of the contract's value related to the sale of goods, the CISG was still inapplicable under Article 3.2, because it was a turnkey agreement that had in its very core extensive engineering, construction, installation services, and had the buyer and seller engaging in mutual duties of assistance with each other, making the exclusion under Article 3.2 perfectly applicable. To them, I would.
Yeah.
Thank you.
Stop this, okay?
Yeah.
Yes.
So much.
You're okay.
Yes.
Right.
Okay, so to demonstrate my point in the case at hand, the tribunal could please follow me to page 11 of the case files, 13 of the PDF. This is the purchase and service agreement. Article 4 details respondents' responsibilities beyond payment. The first paragraph reads, and I quote, "The customer is required to use its best endeavors to ensure the finalization of the project within the agreed schedule by supporting the contractor where possible and taking all steps necessary from its side." If this review is with me.
Yes.
And the second paragraph of the same article reads, "Delays in the fulfillment of any of these obligations may endanger the delivery of the plant in accordance with the timeline in Article 3. End quote. As a buyer, respondent wasn't simply exchanging goods for money. It was engaging in mutual duties of assistance with claimant, a telltale characteristic of turnkey agreements, to ensure the operability and functionality of the plant, which was at its ultimate interest. In fact, if the tribunal could please direct its attention to page 10 of the case files, still in the PSA, 12 of the PDF. In the preamble of the contract, I will read from paragraphs 3 and 6, starting with 3. Whereas in pursuance of those objectives, Equatoriana Wind Power intends to build a plant for the production of green hydrogen and possible derivatives. And in the last paragraph, whereas both Green Hydro PLC and Equatoriana Wind Power are committed to jointly building the plant and making it operational. Quote. This is a joint build venture. In fact, Claimant is an engineering company. It's not a production. It doesn't have merchandise production responsibilities. That is why it was hired. Such, the parties clearly highlighted the service provision component of the PSA, making the CISG inapplicable under Article 3.2. Now, as to my second argument on the inapplicability of the convention. Claimant argues that the exclusion under Article 2B can't be applied here because the reverse auction happened in a public tender process. But members of the tribunal, not all public tender processes have auctions, but this one did. And the convention is perfectly clear. It excludes sales made by auction. Claimant has also failed to define what is an auction for the purposes of the CISG. According to Professor Ingeborg Schwenzer, that is a public, competitive sale governed by domestic law in which all the bidders are present in the same place and the award goes to the highest bid. All of these essential characteristics can be found in the reverse auction. It was public, it was competitive, it happened in Equatoriana, the award went to the best bid, and it was governed by the public procurement law of Equatoriana. In fact, Claimant has also not mentioned why auctions are excluded from the convention. And according to the Secretariat commentary, there are two reasons behind this exclusion. The first reason is that in auctions, parties typically don't know each other. And to prevent a surprise application of the convention, then auctions are excluded. This isn't an issue. There was a registration step, respondent knew the identity of the bidders. But there is a second reason for excluding auctions. And that is precisely the fact that they are governed by domestic laws. And domestic laws are variable. And this variability doesn't match with the CISG's goal of uniform application set under its Article 7.1. As such, because we had an auction that happened, it was governed by a domestic law, the exclusion under Article 2B is perfectly applicable, despite the fact that it happened in a public tender process. Now, I will move to my second submission. Having demonstrated that the CISG is not applicable, Respondent will demonstrate that the parties have validly excluded the convention's application. In this point, counsel for claimant argues that there has to be an explicit exclusion of the convention for it to be valid, and then states that there are only two valid reasons for excluding the convention. To do so, it cites primarily the CISG Advisory Council opinion number 16. But that same opinion in its Article 3.7 states, paragraph 3.7, sorry. It follows that while implicit exclusion is possible, intent to exclude is not to be readily inferred for the purposes of Article 6. Yes, threshold for implicit exclusion is high, but it is possible. And that threshold, according to the same Advisory Council opinion, is the party's intention, first and foremost. That is what defines the validity of an implicit exclusion. And the CISG provides its own hierarchical tools for interpreting party intention, which are set under Article 8 of the Convention. Article 8 has 3 paragraphs. We only go to paragraphs 2 and 3 if the requirements under Article 1, paragraph 1 aren't met. And under Article 8.1 of the CISG, it is a party's intention that is paramount in interpreting statements and conduct if the other party could not have been unaware of that intention, which is exactly what we have here. Respondent's intention to exclude the convention was evident, and claimant could not have been unaware of that. First, the Article 29 of the PSA had been changed. Claimant was aware of that change because it interacted with previous versions of the model contract. So we knew that the new contract, which it was signing into, didn't mention the CISG anymore. And second, there is a history behind the exclusion of the mention of the CISG. And that history was made public by the government of Equatoriana in a press release. And that claimant had to be aware of. Was a party interested in contracting with a state-owned company. Understanding the legal and political context of Equatoriana was in claimant's own best interest. And regarding whether a party has to be aware of the other party's intention, according to Professor Brunner, if it is found that indeed the declaree has to be aware of the declaring party's intention, then objective interpretation of statements and conduct can't protect the declaree. In fact, in those cases, it is up to the declaree, claimant in this case, to make further inquiries if there are any case of doubt. If the tribunal could please follow me to page 30 of the case files, 32 of the PDF. This is Ms. Joanna Ritter's witness statement. In paragraph 11, Ms. Joanna Ritter, respondent's head of contracting, details how the issue of applicable law went. In the 6th line, it reads, and I quote, in paragraph 11, sorry. As neither Mr. Cavendish nor Ms. Faraday are lawyers, it was agreed that the issue should be left to the lawyers for discussion. There was no further discussion on the issue. Claimant knew the model contract had changed. It no longer mentioned the CISG. It had to have known that there was a reasoning behind that exclusion, which was to strengthen the law of Equatoriana. And yet, it signed the contract without ever circling back to discussions on the matter. And that only strengthens respondent's position that the claimant either understood that the CISG was excluded and wanted to keep it that way, or wanted the CISG excluded itself.
Mariana, if I may, you mentioned the convention relies on the party's intention. But if according to Ms. Joanna here, there were the issue should have been discussed, but there was no discussion. If there was no discussion, how would you conclude the claimant knew and agreed on that if there was no discussion? Is like a presumption, you know, because if there is an intention, if you can conclude a real intention, is that okay? But there was no meeting and the issue was not discussed at all, as far as I am reading on paragraph 11. So I am quite confused. If you would clarify.
Madam Arbitrator, for an implicit exclusion to be valid under the CISG, it's sufficient that we use the threshold in Article 8.1. That is, one party's intention has to be clear and the other party cannot be unaware of that intention. So the fact that there was no express discussion between the parties, neither party expressly stated anything relating to the issue of applicable law, doesn't change the fact that Respondent made its intention to exclude the CISG clear in two ways. It changed the model contract, and the press release made by the government of Equatoriana, and Respondent is state-owned company, made it clear that the change related to a desire of the government to strengthen the law of Equatoriana. Additionally, this entire project relates to strengthening Equatoriana in itself. Members of the tribunal, I see that my time is just about to run out. If I could have an additional 15 seconds. Thank you.
Yes.
As such, the parties were clear in their intention to exclude the CISG, even if that intention is implicit. With that, Respondent reinforces its submissions and thanks the tribunal for its time.
Thank you, Madam Arbitrator and members of this tribunal. Respondent's strategy to disconsider the fact that the plant is a good to be manufactured essentially consisted upon pointing out that a plant in the window production plant case would be movable, while the 100 megawatt plant in the present case would not. With all due respect, members of the tribunal, the attempt to mislead the tribunal must not pass unnoticed. The truth of the matter is this tribunal has already recognized on procedure order number 2 on page 53 of the case files, more specifically on paragraph 16, that the plant was movable at the time of the delivery. Page 53 of these case files, Mr. Arbitrator. And if the tribunal would like, I could obviously, okay. More specifically, paragraph 16. It starts on page 53 and then it goes to page 54. It reads, and I quote, where the components produced by volta transformer, electrolyzer, to be delivered directly to the construction site. Yes, as the transformer and the stacks were produced in Equatoriana, it was planned to have them delivered directly to the site where they were to be, next page, connected to the existing infrastructure, electricity, pipes, and buildings. Here's the key point. The connection of the transformer, the stacks, and the various other elements of the core system was to occur in a way which allowed their easy removal in case of maintenance or replacement. End of quote. In other words, the components of the plant were movable at the time of the delivery, and the plant obviously was movable at the time of the delivery. Thank you.
If I read it, I know we have a time frame, but the same paragraph 16 mentioned that they were producing in Equatoriana, so they are not international. I'm quite confused, and if not being international, is the convention is not applicable. So your same argument goes a different way.
Madam Arbitrator, I agree that it can be confusing, but the truth of the matter is, for the internationality of the CISG, it does not matter if the goods even cross borders. That is, for example, supported by Professor Franco Ferrari, as he cites, and I quote, the contract can be considered international even in those cases where the goods do not cross any border. End of quote. Thank you.
Okay, so you have more time.
Members of the tribunal, the definition of what is a good under the CISG isn't contested here. It's movable and tangible at the time of delivery, even if the finished product is immovable. But the plant was the good, apparently, according to respondent's arguments. But the plant was not movable. Plant is a turnkey construction. As such, at the time of delivery, when respondent paid for it and received it, it was not movable. Even if, when claimant began the construction, the plant's individual components were. Such, the argument that the plant itself is a good to be manufactured can't stand here, because it was never movable to ensure its operability, which is what any party wants in a turnkey agreement such as this one. Thank you.
Questions?
Thank you. Thank you so much.
Congratulations.
Thank you.
I know.
Yeah.
I guess it better be so many.
Parabéns, pessoal. Aí, passa pra